We'll just go over SIJS. I'm going to spend a bit of time on the basic legal requirements because I think that's, I would say, the most important thing for you to know is just get a sense of who might be eligible for this relief. And then after that, I have a section that talks about the procedure that focuses on the juvenile court part of the case and what happens there, what you might be doing. And then also it gives an overview, the second part, which is what the immigration procedure itself is and talks about all the steps on the immigration side. So I think we'll focus on the legal requirements. I'll also talk about the juvenile court stage. And I think on the immigration stage, you all will probably not be handling that part, so except for the immigration lawyers. So I'm not going to spend a lot of time on it, but I'll just give you a brief overview so you have some sense of once you get this order and you turn it over to an immigration attorney or an accredited representative, someone who's going to handle the immigration part of the case, at least you have a general idea of what it is that they do. So the first requirement is that the child has to be under the jurisdiction of a juvenile court. And the thing that's important to know here is that when you think about what is a juvenile court, what you want to do is look at the federal regulation, and for Nebraska, it would be a court that has jurisdiction under Nebraska law to make judicial determinations about the care and custody of juveniles. And so what that means is that whatever label Nebraska might put on their court is not determinative for immigration purposes. As long as the court has jurisdiction to make determinations about juveniles, that court for federal immigration purposes will be considered a juvenile court. So in Nebraska, it has been recognized that Nebraska county courts and separate juvenile courts in 3A and delinquency cases are juvenile courts for purposes of SIJS findings. It is also the case that courts that maybe don't think of themselves as juvenile courts, like probate courts that handle guardianships, are also juvenile courts for purposes of SIJS. And there was actually, March of this year, there was a decision out of an administrative appeals office within the federal government. The Omaha CIS office had denied an SIJS visa for a child who got an SIJS order in the probate division of the county court of Douglas County. And the denial was because this is a probate court, this isn't a juvenile court. So the attorney appealed, and on appeal, the federal government said, you're right, this order out of the guardianship proceeding is a totally legitimate SIJS order. This court is a juvenile court in our eyes because it's clearly making custody decisions about children, and we don't care, the federal government, we don't care what you call the court. As long as the function is the function that we need, that's what we're concerned about. So you can do SIJS cases through guardianships, and I think Kevin Rooser at University of Nebraska has handled those. You can also do them through independent adoptions. And so you can do it for children who are being adopted out of the state child welfare system, but if there are families who are doing adoptions completely outside of the state system, that court that's making custody determinations about the child can also be a court to make SIJS findings. As far as I know, no one has done this in adoption proceedings, independent adoption proceedings in Nebraska, so any of you want to be the first people to try it, but it's something that U.S. Citizenship and Immigration Services doesn't have a problem with because they're seeing, in a way, even the reunification prong is so very clear for kids who are going to be adopted. So just be sort of creative and thinking kind of broadly about what juvenile courts can be for SIJS. Now, the child has to be considered dependent on the juvenile court, committed to or under the custody of an agency or department of the state, but it's also, and most recently changed, so that it also includes children who've been committed to the custody of an individual or entity. And again, this is where children who go through guardianship proceedings more easily fit into the category of eligible children. It used to be that in the past you had a child in guardianship, well, they weren't really a ward, they weren't dependent, what were they? Now the law is clear, and the Immigration Service has recognized that children who go through guardianship proceedings are committed to the custody of an individual, perhaps, and so they can be eligible that way. And there is a memorandum that the Immigration Service issued that acknowledges clearly that children in guardianship proceedings can be eligible for SIJS. And I think the same rationale applies and has applied for our cases for children who go through the independent adoptions, that it may be more similar to a guardianship situation. And so you have children, or potentially have children, who can be in a lot of different settings, whether it's with relatives, foster parents, OJS placements, with guardians, prospective adoptive families. And there is a published Nebraska case for children who got SIJS through the delinquency system. And so they were not in a formal foster care setting or in a prospective adoptive home, but they were able to get their findings through the delinquency court. it was actually an interesting case because the judge granted the findings and then withdrew the findings, and then there was an appeal. And the appellate court said, yes, the original decision granting the findings was correct, and so the children were able to pursue this relief.
I have a question. Is
Yeah.
that placement with a guardian, a different guardian, like an adoption guardian, or whatever, that doesn't have to be a U.S. citizen?
So the question is the immigration status of the person who is the child is placed with, does that matter? And the answer is no. The immigration status of the person who's taking custody of the child doesn't matter. They could be a citizen, they could be undocumented, because the reality is that the benefit, the immigration benefit, doesn't flow through that guardian. Having the guardian may be necessary to meet these requirements, but the guardian isn't transferring any immigration status to the child. And so in a lot of our cases, you may have an undocumented family, maybe parents are deceased, grandmother is caring for the child, grandmother's undocumented. She can, at least in our proceedings, the grandmother becomes the guardian and the children immigrate as special immigrant juveniles. The grandmother's immigration status is not relevant to the process, but the child cannot turn around and benefit the grandmother because they can't do any kind of family-based petition for a grandparent. Go ahead.
Would the grandmother's status be at risk?
So the question is about the grandmother's status and whether it would be at risk. In our cases, what I will tell, say it's a guardianship case, undocumented guardians may have concerns about getting involved. What I can say is, in every, hundreds of the guardianship cases we've done with SIJS over 12 years, we've never had a situation where the undocumented guardian has run into problems. We've never had a court investigator try to report the person to ICE. We've never had the judge inquire into the immigration status of the prospective guardian. That said, we can't guarantee you that somehow there could never be a problem or that someone might pick up the phone, but in our experience of 12 years, we've never had it happen. And then what we say on the immigration side is, the immigration benefit is designed for the child. And when we apply, it's in the child's name. When the child goes to their green card interview, it's the child and the lawyer who go to the interview. The guardian is not involved. The guardian doesn't go to the interview. And we do that no matter what the status of the guardian is, so that we don't have a situation where it's like, you brought the guardian last time. Why isn't the guardian here? It's a process that only is focused on the child, no matter the child's age. And so what we do is we just have the paperwork focus on the child, and we don't even identify the identity of the guardian on the immigration paperwork. But again, we can never say, it's impossible that the Immigration Service may not want to dig around. It's impossible. We can never guarantee, but at least we can say, in all the years we've done this, here's how the Immigration Service has treated these cases.
So the case that you were talking about, the grandmother is a permanent resident. Parents aren't undocumented, aren't even in this country, but the youngster. So if grandmother, we don't have to worry about her status because she's got adjusted status, decides to formally become his child's guardian, and that would assist him in adjusting the status?
Exactly. The question was, if you have two parents outside the country, but you have a grandmother here who's a resident and the child's here presumably undocumented, could the grandmother becoming a guardian assist the child? The answer to that is yes, as long as you can show that the reason the child's not with the parents is because of some kind of abuse, abandonment, or neglect. And sometimes in those cases, you may not have the facts to meet that requirement. But you certainly, if you get the guardianship, you're going to meet the first requirement about jurisdiction of a juvenile court. You're going to meet the requirement about the child being in the custody of an individual. And then the question is going to be, is it in the child's best interest to stay? And are there enough facts to support a finding of abuse, abandonment, or neglect? But certainly there are many cases that we see like that, or cases where the parents are deceased or one is unknown. And it's often, it can be an older sibling or a grandparent, aunt and uncle, someone who can step in and be a guardian for the child. And this could be completely outside of the regular juvenile court child welfare system.
Just by virtue of the parents being out of the country, that's not considered abandonment?
I think people take different views on that, and it's something that is going to be governed by Nebraska law. This is where the federal government says you have to find no reunification, one or both parents, due to abuse, abandonment, or neglect, similar basis under state law, and we, the federal government, are going to let you guys figure out what that means. And so the question is going to become, how does Nebraska law treat parents who are outside the country? Do you have evidence that meets requirements for Nebraska law to say that the parent has abandoned the child? And I think it's going to be a state law specific and then fact specific inquiry. I would say that if it's not inconceivable to me that a court could determine that the parents giving the child to the grandparent and having no way to legally immigrate here and not having seen the child for years, it's not inconceivable to me that could in some state or in some situation result in a finding of abandonment. And I think the Immigration Service would need to have some general idea of the facts underlying the court order, but generally if the court makes these determinations, usually the Immigration Service respects those decisions because the federal government has given that power to the state court to make those juvenile court specific inquiries. So it's not outside of the realm of possibility, but really is going to depend more on your state law and then what your judges are comfortable doing. Go ahead.
What about the case of like the single mom, the dad who hasn't really been around, if you only need one parent?
Right. So the question is about what do you do? You have the child, and the child's living with the mom. Is that, or maybe the child's living with the mom? Okay. So the law used to say you couldn't have reunification with either parent. So it meant the only children eligible for this were ones who were clearly not going back to either parent. The law has changed to say one or both parents, and about, I want to say it's within the past 4 or 6 weeks, the federal government, U.S. Immigration Customs Enforcement, in the context of a removal case, filed a pleading saying, we have consulted with the counsel at USCIS, and we have confirmed that a child who is actually living with one parent, as long as the other parent is out of the picture due to abuse, abandonment, or neglect, can be eligible for SIJS. So if you have a child in out-of-home care, father is completely out of the picture, maybe not going to reunify with the mother, the child could still be eligible for SIJS. Beyond that, if the child is even living with the mother, the child may be eligible. The only caution I would give you is that the only clear interpretation we have of this is the DHS position that they've given in this one court proceeding. And we've actually gotten SIJS visas approved for children living with one parent. But there's nothing to say that the government couldn't promulgate regulations that change their position, or that you could get an adjudicator who didn't want to approve in a case like that, and then it goes up to on appeal and they change their position. So it is, I think it's an area to proceed with some caution, but I think that as long as you have a really clear case as to one parent, you will probably be okay. So just keep that in mind. It is a difference, and maybe even different from the SIJS case that was handled here earlier. Maybe it's a sort of different situation. But again, it also makes it easier on those cases where in the past you thought, okay, the child definitely not reunifying with the mother, getting reunification services as to the father. We really want to help the child with the immigration case, but we need to wait out, 6 months of reunification services to the dad, but we kind of all agree it's not going to happen. If you're in that situation, you can actually go ahead and work on SIJS now, because as long as you know no reunification with the mother, even if services are being provided to the dad, you can still move forward because you have that one parent at least who's not going to be reunifying with the child. Yes?
If you have a situation where a parent has been deported, and there's only one parent that's in the picture, the other parent is deceased, and the parent that's still living has been deported, and that's the only reason why the child is in state custody is
Right.
because the parent got deported. The parent could take the child back, but the child would have to go to Mexico
Right.
to be reunified with the parent.
Right.
Would that be a situation where the special immigrant juvenile status would not be available because reunification is possible?
If reunification is, the term here is, let's see, here we go. That is not viable due to abuse, abandonment, or neglect. If you had, say, one parent was totally out of the picture, then theoretically, whatever the deported parent situation was, you could theoretically rely upon the absence of the other parent to get the finding. But practically speaking, if the other parent is available to properly care for the child, it's just going to be in a different country, not the United States. My feeling on all of these cases where you're dealing with a parent who is potentially being deported and the only reason the child is in care is because of the immigration enforcement action, my belief is that the determination about whether the child should be reunified with the parent should really be handled independently of this question about special immigrant juvenile status. That there needs to be a determination made on all of the evidence about whether the child should be returned or not to that parent. If the decision is ultimately that the child will remain here, then I think you could go ahead with SIJS in a case like that. But I think that what you don't want is for the prospect of SIJS to create the situation where the child is not going to return to the parent. And that's just my belief based on my feelings about immigrant families and often legitimate reasons why they're separated, and then what I believe are not legitimate reasons created by the federal government through immigration enforcement actions. But certainly there have been cases where parents have been deported and either the parent doesn't wish to take the child with them or the child doesn't wish to go and there's been some resolution. Then I think you will be able to pursue SIJS for the child. And there is the best interest requirement. I think that, let's see if it's the next one. These are just some examples of when reunification may not be viable. But again, there's a whole host of ways. It also has to be in the child's best interest not to be returned to the parent's home country or the child's home country. So if there's been a determination it's in the best interest of the child to go back to Guatemala, then they're never going to meet this requirement either. So this is a part of the SIJS analysis that is one that the federal government clearly has told the state, this is your area of expertise. There's no regulations that say, here's what you have to consider, here's how you do your analysis, or even we want you to provide us with your full legal analysis of the best interest. They're basically saying, you state courts, make this determination about the child's best interest. And honestly, this requirement is interesting because it's one of the only places in immigration law where anybody ever cares about the child's best interest. And it's unique because in so many other ways, when you're talking about parents and children being separated, parents potentially being deported, the reality is that what's in the child's best interest is pretty much irrelevant to the analysis of whether anyone gets deported or not. That the idea that you could come here in the US and have a baby and somehow that US citizen baby is gonna save you from being deported is like a myth that's beyond untrue, because the immigration law has been set up in so many ways to prevent you from being able to take advantage of a situation like that. And so the best interest determination here is very unique. And I think is why the federal government is not trying to make that determination on their own. And so this is the place where I think some of the issues that come up about parents facing deportation, you know, may create a hurdle to SIJS because you may not get past this point.
In your experience, what kind of standards are given the most weight in determining the child's best interest? If you've got, for example, you've got a child who, parent's been deported, well, you've got, it's going to be in the child's best interest not to be separated from their parent, but at the same time, if you've got a child who's been in the United States their whole life, they've well established here, they don't speak the language of their home country.
There are all these things, and these are just things that I've sort of put up here as things that I know have factored into decisions in the past, but again, there's no exhaustive list that happens. I think that really, because SIJS does not require the termination of parental rights, there's really nothing in the SIJS statute that talks about you have to have parental rights terminated, here are the standards you would use for that. Those determinations are actually, I think, separate determinations. And so if you're talking about terminating parental rights for a parent who's been deported, that analysis is really not one that's going to factor into what the Immigration Service, I think, perceives as looking at the child's best interest for SIJS. But again, you can be creative. If you're the attorney on the case who's filing the motion, I think you can be creative with what kind of evidence are you looking at, what kind of factors do you want the court to consider. And so I think people have very different approaches on that. I honestly think, for me, in most of my cases, I get involved long past the point about a decision, not long, but the decision about reunification has pretty much already been made when I get involved. And frankly, that's when I like to get involved, because I think that there can be inclinations to want to monkey around with the juvenile case in ways that I don't know that are terribly helpful. But usually I'm sort of have gotten there, at a later stage of the game. But I think that people have, by the time I usually get on a case, the decision about the child staying has pretty much been made. And if the child is going to be in long-term care, particularly if they're going to be adopted, I think that best interest determination is really kind of uncontroversial.
So where we're at right now, we're on requirement 4.
Right.
Okay, so 1, 2, 3, 4, those are all found by the juvenile court.
Exactly.
And then that's submitted to what immigration court or whatever. But so when we talk about best interest and factors to consider, if I file this in the juvenile court and say, I'm asking you to make these findings, I need to, it's not enough for the juvenile court to simply have an order that says, the juvenile court finds it's not in the best interest to return the country, period. There needs to be factors. Is that what we're
They don't have to be listed. What I would do, they don't have to be listed on the juvenile court order. If you look at I think it was page 37, was the sample California order. That one is, you'll see, completely devoid of facts except where was the child born and what county is the child in. So what I would want to do if I were you is to talk to somebody who, and Kevin could tell you, who handles cases out of the Omaha CIS office and say, what does the Omaha immigration office want to see in an order? Because some immigration offices want to see a little more detail. And others are perfectly happy to take an order that's devoid of all information except the child's name and place of birth, and will accept that order without listing the factors out. My general preference is to not provide a lot of detail. My preference, and you'll see in the sample, is to provide an order and then provide a case summary so that the immigration officer knows the general situation for the child, but I don't ask the juvenile court to make very detailed factual findings. That may be something that the immigration office here might want to see, but I don't believe it has been the case. It could be that the juvenile court would want to make very specific findings, but what you really need are the basic requirements. It just can say it's not in the child's best interest to return to Guatemala. You don't have to put the reasoning on the face of the order.
How much are they going to scrutinize the findings?
Right. So it's hard to say because these are all adjudicated by individual officers, some of whom may want to scrutinize a lot or may not. If you take a look, there's that CIS interpretive memo that I cited. It gives directions to the officer that generally the officer is supposed to be accepting the juvenile court findings and the order on their face. They can do some inquiry into whether they think the case is bona fide. What they're not supposed to be doing is regularly issuing requests for evidence for you to copy the juvenile file and give them the motion and give them all the materials and give them everything in the file. They shouldn't be doing that, which is why I like to give them a case summary. That way they have the findings and they get enough information so that their curiosity is satisfied, but not so much detail that it raises more questions than it answers. So I think that if Kevin has been handling the cases or some case out of Omaha, he would probably have a pretty good idea of what they're expecting. But my sense is that generally CIS is not expecting incredibly detailed findings. What they're expecting is an order that at least makes the basic findings. It is true though, if you give an order that says reunification is not viable with one or both parents, period. They're not going to accept that because the statutory requirement is that it has to be due to abuse, abandonment, neglect, or a similar basis. So they want those words in there somewhere, but you don't even have to check the box and say which one it is. Our orders typically say the child can't reunify with one or both parents due to abuse, abandonment, neglect, or a similar basis under state law. And that's it.
That's it, yeah, because I'm going to probably file something like that, but I just want the juvenile court to be vague, and I just want to make sure that, they...
I think that my approach is be vague in the order and be a little more detailed in the case summary. Because what you don't want is to give the Immigration Service nothing, because then they really want to know what's going on. Whereas if you give them just a bit, then they're sort of satisfied. And so in the materials, I actually gave you a sample immigration packet, and there's one page that's a case summary, and that's what I do. And you'll kind of see it's like enough to tell them who this kid is, and that's basically it. So that's my suggestion there. One of the things to remember, I'll just give you a couple things on the SIJS regulations. These are a couple of additional requirements. And one of them to just keep in mind is that these SIJS applications have to be filed before the child turns 21. So from the Immigration Services perspective, child is a person under 21. As long as you file when the child's under 21, you're set. But you need to file the applications while the juvenile court case is open, while the court has jurisdiction over the child. So if you have a situation where the child is turning 19, the case is going to close. Even though the Immigration Service will accept up to 21, you are going to need to get that application filed before the child turns 19 if on the 19th birthday the case is going to close. So in Nebraska, you may be operating on a shorter time frame because of state law, but the Immigration Service itself will accept up to the age of 21. And the good thing about this is that as long as you file by the time while the child is under 21, under juvenile court jurisdiction, even if the child turns 21 or the case closes, as long as the case closes because of the child's age, the child is going to be protected and able to complete their case, even if they age out of your juvenile court system. So what you want to make sure to do is to get everything on file, or have the immigration attorney get things on file while the child is under 21, under juvenile court jurisdiction, and get proof of the filing. But as long as you have those things, you're going to be protected even if the adjudication of the cases takes a little bit longer than you need. Which is why the sense of like, even if you discover one of these on the eve of some big action on the case, it's still worth figuring out whether you can hurry and get one of these on file, because you may be able to do it quickly and then protect the child and get the residency for the child, even if the case closes in the meantime, and even if the child were to turn 22 years old in the meantime. That's one of the issues. Unmarried. This usually doesn't come up, but it's important to know. Child cannot be married. Child can be divorced. So if you have a child who gets married without your knowing it, and you've got this application pending. If the child wants to be a resident, the child would need to get divorced, but they will not approve SIJS for a child who gets married. So it's another reason why having the case resolved quickly is helpful, because it is a clear requirement under the regs. And then I already addressed this, but this is the question about continuing juvenile court jurisdiction. It used to be that you would need to have the juvenile case open for the whole time the immigration applications were pending. And in some states, before the 180-day adjudication deadline, literally these cases could sit for 5 or 6 years. And then the minute the child turned 18, they would deny the case. And so it's less of an issue now because of the deadline, but it's, I think, always a good idea to try to resolve the whole immigration case before the juvenile court case closes, particularly if the case closure is not due to the age of the child. Say that you have an 8-year-old in the system and you're going to close out the case because, I don't know what, there's a guardianship in place, somehow you get to close it out. If I were representing that child, I would ask you, please don't close this case out, wait for the whole immigration procedure to be done, because I'm going to have a hard time arguing the closure was due to age, because age is the protecting element. And if the case closure is not due to age, it's harder for us to argue with the Immigration Service that they should still be able to approve the application. Similarly, I think it would always be great to not finalize the adoption before the child's immigration case is finished, but my understanding from yesterday is that there's a very short time frame in which, under Nebraska law, adoptions need to be finalized. So what I would say is, in a case like that, to get the immigration application on file before the adoption is finalized. If you need to finalize the adoption, finalize it. If there's any way, and I don't know that there is, to keep the case open post-adoption, I would do that. But regardless, there is some protection in the current regs that suggests that if the child met the eligibility requirements but was subsequently adopted, that shouldn't destroy their eligibility. But the general rule is just like, try to do this sooner rather than later and try to complete it, I think, for legal immigration purposes, but also in terms of the child's ability to sort of make do with their lives and their new immigration status. The earlier they have that, the better it's going to be for them, and probably for those of you, particularly for children who are transitioning out of the foster care system, to be able to take advantage of some of the benefits that they would have. Now, one thing to keep in mind is that in order for the Immigration Service to approve the case, they have to consent to the SIJS findings. And basically, this is just a requirement, I think, that the federal government has, saying, we've given you a lot of ability, state court, to make these findings, but ultimately, at the end of the day, we're the ones who get to decide whether or not this child gets an immigration benefit. So we reserve something called consent. This basically means we decide whether the application is bona fide or not. And if we think it's bona fide, then we're going to approve it, and our evidence of approving it is our approval. So there's no process to go through, it's just submitting the application. If you do have a child, though, who is in the custody of the federal government, there's a more complicated consent procedure you have to follow, but I think it's probably unlikely any of you will deal with that, in part because Nebraska has no immigration facilities for juveniles. So there won't be juveniles housed here in Nebraska in immigration facilities. But if for some reason a child of yours on your caseload ends up in the custody of the Immigration Service, and we'll talk this afternoon about how that could happen, then you should just call me and we'll talk about this process. But basically there's an extra procedure you would need to go through. But just because the child meets the basic eligibility requirements for SIJS doesn't mean that they're home free in terms of their legal status, because the child also has to qualify for adjustment of status. And again, we talked about that earlier. This is the process where you go from being undocumented or being a person with an approved SIJS visa into formally becoming a permanent resident. And when you do that, you have to meet a whole bunch of additional legal requirements. And many of them are difficult to meet for most people, but Congress has said for SIJS children, we're going to remove most of the barriers to permanent residency that other people have. So for example, like I mentioned before, if you enter the country without permission, it's really hard to get your green card here, but not for these kids. Illegal entry is not a bar. Delinquency dispositions are not bars to their adjustment, and we'll talk more this afternoon. Even if you have a child who has an old deportation order, that's not a bar to getting this status either. So if the child's currently in immigration court proceedings or has an old removal order, they may still be able to complete this immigration process. You would just want an immigration lawyer on the ball to handle it. The grounds of inadmissibility specifically, I just listed them at pages 55 and 56. There are a whole bunch of reasons people can have problems getting their green cards. And most of them for SIJS kids are waivable or inapplicable. The real big issues that come up on our cases, ones where we have problems, are children who have been dealing drugs. If you have a child who has been dealing drugs, even if they were never arrested and if the only person they ever told was you or me as the immigration lawyer, I would not file for SIJS for them, because being involved in drug trafficking, even absent an arrest, is a non-waivable bar of inadmissibility. So those kids are not, they're just out of luck here. Also, many kids who get convictions in adult court are out of luck. And so this afternoon we'll talk about the big problems that come up for children who are filed on an adult court. Go ahead.
Odd question.
It's-
Most of us that are working in the juvenile court system have been court appointed. So we're states paying our fees. We're not immigration lawyers. You keep saying the child's immigration lawyer.
Right, right.
How does a child's immigration lawyer get paid?
Well, this is an interesting question. Most children's immigration lawyers don't get paid by the county or the state, because many states don't fund those kind of services. So there are a couple of ways. One way is that the legal services are provided by free legal service providers. And so at the end of the day, and this is so that you're not all dismayed, at the end of the day, there's a long list that I put together of people who provide immigration legal services for free. In LA County, child welfare system actually has so many of these children that they have 5 social workers and all they do are file these applications. But what happens in a lot of other places is that the court may appoint or ask for an immigration attorney pro bono to take on some of these cases, or they may actually appoint someone and pay a fee. And so what you really want is someone with expertise in this area, and frankly, most of the people with a lot of expertise tend to be more on the nonprofit side, because this is not a money-making venture for anyone, honestly. But what happens is that even if you do appoint, if the court were to appoint an immigration attorney to handle the case and pay them hourly, the amount of time it takes to do one of these cases is actually relatively small. And so the bang you get for the buck of appointing someone to handle the case is huge. But I would say that and maybe you know this, but the world is full of really shoddy immigration lawyers. And so you really want to make sure that the immigration lawyer who's being appointed for the child is actually someone who's a good attorney and who, you know, has or is gaining enough expertise to handle the cases. So you want to be careful that in the effort to get a lawyer, you don't just get some lawyer who makes a bigger mess than not. But that's why I put together the list of resources, so that when you do find a child like this, you can have somewhere to turn. There are definitely counties or states where the child welfare workers do the immigration applications and they don't have an attorney involved. And so that's certainly a possibility. I think that can feel very daunting, though, for a caseworker or for an HHS attorney to take that on top of everything else, or for a GAL to do that. The Immigration Service will allow attorneys, they don't have to have immigration expertise to file the applications. But in an ideal situation, you would want an immigration attorney to be assessing the cases, at least to make sure, do an initial assessment to make sure that there's no red flag you're not perceiving before you file an application. Go ahead.
On that same issue,
Yeah.
last I checked, it was about $1,200 just to file the paperwork. Is there any, for indigent children, because we just in Nebraska have a law
Right.
passed that we
Use funds. And
can't use funds.
the question's about the fees. The immigration fees are pretty pricey. The I-360 visa petition for SIJS is free, so that's good. The green card application is about $1,000, take or give a little bit. But that fee is completely waivable for people who are low income, and I think that all of my SIJS cases I have the fees waived, because the fee waiver, there's a sample in the packet, and the fee waiver is going to be based on the child as a household of one. And so unless the child is rolling in cash, you will be able to get that fee waived. So the incidental fees will be the cost of photos or a medical exam for the child, but the big ticket items of the application fees are waivable. And so I wouldn't worry that that should be a hurdle or a barrier, because you should be able to get those fees waived for the child. And there's actually, the Immigration Service up until last year had no form to use for a fee waiver. That was like how much they wanted to give fee waivers. But now there's actually a form that you can fill out that's official, that is for a fee waiver, and it's clear that SIJS children are eligible to get those fees waived. And so you can file that, and we've been successful in all of those cases. All right. So just on grounds of inadmissibility, I'm just mentioning that drug trafficking is a big problem. And for those of you to see, anyone who's never seen a green card application wants to see it, pages 77 to 79 are particularly useful to look at. This is a green card application that has to be filled out by anyone seeking permanent residency, whether they're 2 years old or 79 years old. And there's a huge list of questions which frankly are often very uncomfortable to be asking your 9-year-old client, yet you need to review the form with them. A huge long list of questions. Have you ever been a spy, a terrorist? Do you intend to overthrow the government of the United States? These are all questions designed to get at grounds of inadmissibility. And so even though they're sort of theoretical issues and problems, every person who applies has to answer these questions. And this is actually where the issue of drug trafficking can come up and be a problem. Because even if the child has never been arrested for this, there's clearly a question on here about drug trafficking. And so if you have knowledge the child has been involved in drug dealing, unless you have some great legal argument to get around it, you're going to be revealing that information. And if it makes the child ineligible, then you will not be creating a great immigration situation for the kid. So now I'm just going to go through real quickly the SIJS procedure. And again, I'll spend just a few more minutes on the juvenile court part. The immigration part, I'll leave it to you to review yourselves. But these are 2 stages, but they're not mutually exclusive. They're probably going to be going on at the same time. But the reality is that you need to at least address the juvenile court stage first because you need that SIJS order before you can go to the immigration stage. And so the first issue, and honestly it's often the most difficult one, is even anybody thinking about whether this child might be eligible for this relief. And so I included on pages 24 to 29 a screening sheet that we use for the SIJS intakes. And so you can just take a look and see what kind of questions do we ask the children, trying to figure out what kind of information you need to gather. So in the materials it's 24 to 29. I would caution or suggest that for any of you who are trying to gather this information, knowing that you're gathering it because you want to benefit the child, you want to make sure that the child or the family understands the motivation for asking these questions, because I think that you may encounter some resistance or concern or fear on the part of the child if you start asking a lot of questions about immigration and you don't tell the child why you're asking. They may be worried that what you're trying to do is get them deported, and you may end up getting incomplete or incorrect information as a result because they're concerned that you are not acting in their best interest, but that somehow you're trying to trick them into giving up some information they shouldn't have. And frankly, I would say for those of you who work on the delinquency side, that's particularly the case. I think for the attorneys who represent the kids in delinquency, maybe a little bit less, but anybody who's working on the state agency side or even the court side may run into that a little bit more. Go ahead.
I see one of the questions that's on both the form, the application form, and your checklist. It deals with whether or not the child has ever received public assistance.
Right.
And you had said that those are some of those questions they ask to screen out who are inadmissible.
Right.
Can you explain that a little bit?
Sure.
If you have a child who's been receiving Medicaid,
Right.
would that be public assistance? That might
Be a problem? So the question about public benefits and how does that interact with the grounds of inadmissibility. There is a public charge ground of inadmissibility, and basically the government is saying, we don't want you to come here and then take all our government benefits, so you need to show that you can support yourself. But luckily for SIJS kids, that is waived. And it's logically waived because the kids are all going to be, or most of them are going to be dependent in some way on the state. So it's actually not even applicable to these children. But we always ask the question because we may want to reveal it. The form may say, do you receive public assistance? And then we may reveal the information. But that information is not going to be used to the child's detriment. It's just that we may need to reveal it. But yeah, that's not a concern. It's sort of like by definition, these kids will be getting whatever benefits they're entitled to, and so it's not a concern. But it is a concern for people who do other kinds of immigration, family-based immigration, other things, which is partly why this form of relief can be preferable, because the requirements that you need to meet can be lower and much easier for SIJS than they might be for some other kind of immigration benefits. In family-based, you need to have someone sign an affidavit of support, typically, that says, I will support this person, and if they seek government benefits, you can come sue me to get the government benefits back, potentially. So this is the screening part of the case. And the next part of the case is going to be obtaining the SIJS findings. And again, you haven't handled cases, many of them, under the old language, but you just want to make sure the version, if you start trolling the internet for resources on SIJS, make sure you're seeing recent things, because there were the statutory changes that are significant. So you just want to make sure what I have here for the California samples is all up to date. So you would get the SIJS findings. And again, the procedures for doing it I think are going to vary depending on what kind of court you're in, what is the posture of the case. And again, the Immigration Service is not going to be concerned about who filed the motion or why, exactly when or how, but you want to make sure that you're thinking about the process as the case goes along. Typically, we've had cases, I think you guys have, where it's been the GAL who's filed the motion, HHS attorney, a county attorney. the Immigration Service doesn't care who files it, as long as the court will recognize that person as a filer. And again, delinquency case, you could have a defense attorney or a GAL, anyone who would be able to file a motion there. And again, the timing is really just dependent on when does the child meet the eligibility requirements. So you want to make sure you don't file the motion if there are reunification services as to both parents going on, because the court will say, I can't make that finding about reunification not being viable if the permanency plan is reunification and you have it going on for both parents. In the guardianship or adoption cases, the more independent ones, usually the SIJS motion is filed at the same time as the initial guardianship or adoption petition. There's no requirement that it be that way, but that's typically how we handle it. If we're going into the guardianship or the adoption knowing there's not going to be reunification with the parents, maybe they're deceased, there's no reason, at least under California law, for us to have to wait, because there's not going to be a formal reunification process and services that are provided through a more independent route of a guardianship or an adoption. And then, again, the evidence in support of the findings is really going to vary, and really I think most of this is going to depend on what does your juvenile court judge or state court judge require. In the case, the 2009 case out of Nebraska, you actually had both children, foster parents, HHS caseworker, everybody testified at a big hearing about SIJS. But I would say that generally, in my experience, the cases are usually decided on the facts that have already been established in the case file through the evidence that already exists as the case was adjudicated, perhaps with some additional declarations from the children or caretaker. But usually when we get to the point of SIJS here with cases that have been worked up for a while, most of the evidence that you probably need is going to already be in the file. And I think the more that judges see these cases, the more comfortable they may be with the evidence that's already been collected. If it's the first time you're doing a case, you may want to, you may need to or want to do something a bit more elaborate. But again, the Immigration Service does not require that you file that evidence with the Immigration Service. They want the order. They're not requiring that you file copies of the motion, copies of confidential or other juvenile court documents. And then because to the extent that an immigration lawyer may be handling the case, they may be confounded by juvenile court and don't understand or know how to even get documents, or they're worried about getting documents. So if you're working the juvenile court side, assembling the documents that the attorney would need would be really helpful. For just like a certified copy of the SIJS order, if the child has a delinquency disposition, just getting copies of those dispositions can be helpful. And then just maintain the child's eligibility for SIJS. And again, this is, to the extent you can keep the court case open, unless it's going to close because of age, is helpful. And then if the child unfortunately picks up some additional or initial delinquency case while the immigration process is going on, you want to make sure that whoever's involved in handling the delinquency case is aware that there's an immigration process happening and can try to work with you to craft the best resolution of delinquency case to have the minimum amount of fallout for the immigration situation. And this afternoon we're going to go in detail about what would that be? What could help a child who winds up getting arrested after the applications have been submitted. And this is the immigration stage, and again, I'm not going to go into any detail, but what you can see is that the basic idea is you would be not you, but whoever's filing the case with the Immigration Service would be assembling all the documents, the application, medical exam, birth certificate, photos, putting those things together. There is a provision in Nebraska law that specifically deals with SIJS and refers to interaction with the consulate to help getting documentation together for the applications. We have had the consulate actually pay some fees in connection with immigration relief for children from their country. We've actually gotten some legal fees from the consulate or some reimbursement for non-waivable fees like medical exam and photos. So again, that may be further motivation to establish relationships with the consulates that are related to the children you work with most, because you may actually be able to get some support for this kind of immigration relief from the child's consulate. Because what you're saying in those cases is not that Guatemala is horrible, Mexico is terrible, but what you're saying is that the child's best interest is to be here, and can you assist as the consulate in making that happen? So I included a sample application packet in the materials at pages 57 to 87. So for those of you who are interested just to see, maybe you want to look at the case summary and see how detailed it is, you can go ahead and check that out. But basically the application gets filed with the Immigration Service, and there is an adjudications deadline of 180 days. the child is going to be fingerprinted and photographed. Even if they're really tiny, they're still going to be fingerprinted and photographed. The Immigration Service will run criminal background checks on people 14 or older, but to create that permanent resident card, they need electronic data of a photo and fingerprint. So the child will be scheduled for an appointment to have that happen. And typically you need some kind of government-issued ID for the child, which is why having a consular ID card or a passport can be helpful in this process. If the child is 14 or older, then they should have an adjustment of status interview or a green card interview. These interviews can be waived for children who are under 14. So all the children in Nebraska who apply for this benefit, their case is going to be handled out of the Omaha CIS office. If you're working with a child who's under 14, it's a great idea to try to get the interview waived, because that way the child doesn't have to go through something that is very stressful for many kids, but also potentially doesn't have to be transported from western Nebraska to Omaha to go to an interview. But basically at the interview, the officer is supposed to be determining whether the child is eligible permanent residents, shouldn't really be digging around and grilling the child on the abuse, abandonment, or neglect. That's not really the role of the officer during the adjustment interview. The child would need to be prepared for the interview. I always do practice interviews with the kids, and then the attorney would attend the interview with the child. Typically, decisions can be made at the interview because most kids don't have issues in their background that create problems, but sometimes there can be a fair amount of delay. If the case is not approved at the interview stage, the applications are not, then you would want to monitor the case with the Immigration Service, and the Immigration Service CIS website actually posts an email and phone number you can allegedly use to contact the Omaha CIS office. But what you want to do is also, I think, keep the juvenile court up to date on what's going on with the immigration case. And part of that is to prevent the case from closing if you need to keep it open. But part of it also is to really, I think, encourage the juvenile court to sign these orders and to see that the fact that they signed it actually had some concrete benefit for the child. So I think it's always, particularly when you get the green card, I think it's a really good idea to do like a status report to the court with a copy of the green card, something to show very concretely what has happened in the case. And there's just some tips for how the case would be wrapped up if it's approved. Unfortunately, if the case is not approved, you have an appeals process for the visa petition, and that's what happened with the case that was filed here in Nebraska through the guardianship. It was appealed and ultimately approved. If the visa petition is approved, though, but for some reason the child is not granted their adjustment of status, then you have a situation where the child could end up in removal proceedings. It is not the end of the world because the child can renew their green card application in removal proceedings, but really this is not the place you want the child to end up. You really want the case to be able to be resolved before anyone darkens the doorstep of immigration court. But it is something to be aware of, that the child may make it into immigration court proceedings completely independently of this application. Maybe they're already in court proceedings. And so for you to know that the child may actually be able to take advantage of SIJS in the immigration court proceedings and still pursue this relief even if their case has been sent to court. This is just one slide I included. I used to have like 6 slides about the DREAM Act, the Federal DREAM Act, and how maybe soon it was going to pass and it was going to address the immigration situation for huge numbers of undocumented kids who've been here for a long time. But the DREAM Act got very close to passage in December 2008 and was not passed. And given the current makeup of the House of Representatives, I can say with some degree of certainty that I don't think you're going to see the Federal DREAM Act moving very far in the next couple of years. So I just included some information on what it is, but it's not something I would say is likely to be cropping up anytime soon. But one thing to keep in mind is that there is a Nebraska DREAM Act. It doesn't address the immigration status of the child, but it does address the child's ability to take advantage of in-state tuition and make college more affordable. So in the materials, pages 119 to 120, I've included information on that Nebraska program in the absence of any federal DREAM Act. So we're going to move on to other forms of immigration relief, but before we do, does anyone have questions about SIJS that they can think of? I think most people were good about asking questions during, and that's great, but you should, go ahead, Kelly.
I guess I was just wondering, as far as the procedures, what you'd be recommending for the child welfare attorneys, whether it be the guardian ad litem applying for the special immigrant juvenile status or whomever, at what point would they be trying to get the immigration practitioner involved? And would it be, I guess, would it be, recommended to the court requesting an appointment first, and if the court doesn't want to do that, or then
Right. I talked to a GAL yesterday because we were talking about the process, and one of the things we talked about was the possibility of, if you identify a child looks like they might be eligible, asking the court to authorize, what he wanted to do was ask the court to authorize the child to be screened by an immigration attorney at whatever cost there was, or if it was pro bono. To do that up front to see if the child even looks like they may qualify. And if so, then the next step would be for either the GAL or HHS attorney to file the SIJS motion and go forward. If it's a very straightforward case and someone besides the immigration attorney wanted to handle it, they could, but otherwise you could just have that immigration attorney retained or pro bono to handle the case. Another way some people do it is to say, I think the child's eligible, I'm going to get the SIJS order, and then I'm going to refer it over to an immigration lawyer and let them look and see if it makes sense to file. And that's definitely one way to do it. I think the potential downside there is that if you continually ask the juvenile court to sign these orders and in only 10% of the cases anything's ever done with them, I'm not sure that it's a great use of resources, but also like not a morale booster for everyone to think that every time we try this, it's not going to work. So you can do it that way. I mean, I often will get cases where there already is an SIJS order, and I'll do my own assessment, and if I think the child is not going to qualify for adjustment, I'll report that, and then the case will be closed out with me. Or I'll assess it and say, you know, this looks like a great case, and we go ahead and file. So I don't think there's a clear right answer, but what I would say is that you want to get an assessment, I would think, relatively early on, and you'd want to try to build those relationships with people who have some expertise on SIJS who are willing to talk to you about these cases. But again, I think it's really going to vary probably county by county and court by court what people are comfortable doing and how many attorneys they have to reach out to do those assessments. Did you have a question? Was it the same question or a different question? That was you.
Can we get rid of the language then about being eligible for long-term foster care?
Absolutely, yeah. That is still in the regulations. If you look at the federal regs, it says that the children have to be deemed eligible for long-term foster care. And that was like in 1992. And my sense is like since then, that's not a good term for people to use, and it's changed. And so the eligible for long-term foster care language is now out of the statute, and it's been replaced by the reunification with one or both parents is not viable due to abuse, abandonment, or neglect. And so if you actually get an SIJS order with the eligible for long-term foster care language, which I think is the sample that's in here because it was an older Nebraska case, the Immigration Service will actually return that case to you and will say, we need an updated order with the updated statutory language. So there is no longer, even though the regulations still say it, there's no longer an eligible for long-term foster care requirement, and you actually don't want to use that lingo in the orders because it'll probably bump you back to the court again.
Did you say if the application was denied, the child could end up in removal proceedings?
Yes. If the application is denied, the Immigration Service conceivably could use the information provided in the application to try to place the child into removal proceedings. Whether the Immigration Service, and maybe some of the immigration lawyers can tell me what they think Omaha would do. My presumption always on these cases is that the government would put the child in removal proceedings. So I'm going to assess the case believing that they're not just going to close the file and put it away. In LA, the general rule is that yes, they will put these children into removal proceedings. Sometimes they'll just close the file and act like nothing happened, but many times they will put the children into removal. And so that's why the assessment of the case is really important, but also the involvement of the child is really important because you may have a child who's 16 years old who you think is like the greatest candidate for SIJS. But if that child doesn't want to do this process and doesn't want to be involved, then I would be very concerned about moving forward with it because the child has to show up for fingerprints, for an interview, has to go through the whole process, and at least in LA, if the child were to AWOL, the Immigration Service would actually put the child in removal proceedings. So it's important, all these considerations mean that even though it's a really great form of relief, you do need to be very thoughtful about how and when you pursue these cases because it's conceivable that the child may end up in immigration court, which is really not a place you want the child to end up. And I don't know if either of you have experience with Omaha CIS. The thing is that around the country, the practices vary. Some offices, who generally are very hard on SIJS kids, will not put them in proceedings. And then LA, which like they love our SIJS kids, their office policy though is to put the kids in proceedings. So here it could be, you know, it could be anything. My sense 2 years ago when I was talking to folks was that they believed Omaha CIS would put kids in removal if they were denied, but I don't know if you guys have any other sense of what you do employment, right? Do you have any feeling? They do.
Or they have in the past.
They have in the past. So that's, I think you have to presume it's a possibility. So that's what makes this very, weighty and tricky, because you don't want to put the child in a worse situation than they were in, but you also want to recognize that there's only a narrow, amount of discretion the Immigration Service is going to have to deny. If the child falls into a non-waivable ground of inadmissibility, if it's waivable, they have some discretion to grant or deny a waiver. They have to consent to the SIJS findings, but as long as they're bona fide, they need to consent to them. So there is room, but it's not unbridled discretion they have because they don't like the kid. But you do want to make sure that if there are some negative facts in your case, that you're building up some equities to outweigh those. So that's why I think it's important to have somebody assess the case who is confident in their ability to put the case forward. But yeah, it is something to be aware of. Go ahead.
Now, with my adult clients, I always had a Freedom of Information Act sent off to the FBI to find out. And I guess I would probably do that for even
Children.
Children,
Right.
because you would be surprised sometimes what comes back.
Right, and the question, or the comment was about what kind of background work can you do to see if there's something the child may not even know about their case. It is possible to do FBI background checks on kids and just see maybe they were apprehended at the border, they didn't tell you, they don't remember, or maybe they have some arrests in another state you didn't know about. You would want to know that. You can do a FOIA to the immigration court and see if they had a case in immigration court. You can also do a FOIA to the USCIS, but unfortunately those FOIAs take like 3 years to get a result, so I don't think that's generally practicable to do that kind of background check, but there are ways to check out the cases if you have concerns, or you could do it, the attorney could do it as a standard practice or do it as, if they have concerns.
I do this as standard practice, and I even have my own fingerprinting. I do the
Right.
fingerprinting and then send them out.
Yeah.
And it's relatively inexpensive. The FBI will get it back to you within 2 months.
Right.
It's much better
To know what you have going into it. So there are ways, it's not just shooting in the dark, but there are ways to do background checks, and I think people will make judgment calls about how much information they need. But certainly, if the immigration attorney wants to make assessments and there's a delinquency record, helping them to have copies of the documents so they can know what the child was charged with, it's going to be a helpful thing to do. Okay, so we're going to talk about some other kinds of immigration relief, and we're going to have lunch in a half hour. So I'll run through what we can get through in a half hour, and then we're going to do the follow-up after lunch. But basically, these are some other kinds of immigration relief, and they're not ones that are dependent on the juvenile court. So now that we're outside of SIJS, these are kinds of immigration relief that children under juvenile court jurisdiction might qualify for, but they're not only for those children. So these kinds of, or forms of immigration may be ones that children can take advantage of, but they're also ones that their parents may be able to take advantage of. So if you're an attorney who is representing parents in these proceedings, or if you have a child who's going to be reunifying with a parent, and there's a sense that the parent being able to straighten out their own immigration case would be beneficial to the child and to the resolution of the case, some of these forms of immigration relief may be of great help. And again, in the resources that I've listed attorneys who have expertise in different areas of immigration law, and some of them, like the Violence Against Women Act, family-based, I've noted in the resources people who specifically deal with those kind of cases. But just because there's no juvenile court component doesn't mean that you can't do some things in juvenile court to help people who may qualify for this relief. So the first thing is family-based immigration, and these are going to be cases, we talked a bit about them earlier, some of the challenges for doing family-based immigration for immigrants who are here in the US. And basically, people who are US citizens or permanent residents can qualify to immigrate other family members, but it can be very difficult to actually make that happen. And so rather than run through the slides slide by slide and just tell you what's there, I'll just give you an example of a woman yesterday who was a caseworker who asked me a question that involved all different kinds of family-based immigration, and she was sort of horrified by the answers that I gave her. She had a US citizen, 4-year-old child, and then siblings, maybe 7 or 8, who were born outside the country. Had a grandmother who was undocumented caring for the children. Parents were out of the picture. And so the question was, the fact that you have this 4-year-old child who's a US citizen, can that child fix everybody else's immigration situation, or can they try to fix it? So the answer is, theoretically, in some universe, yes, but practically, no, and certainly not anytime soon. The reason is because even though this child is a US citizen, the child can't petition to immigrate family members until the child reaches the age of 21. So you've got a 4-year-old, you've got to wait at least 17 years for the child to turn 21. The child turns 21, and then the child turns around and says, okay, my siblings, I'm going to help you with your immigration case. So unfortunately what happens at that point is that we go to a somewhat depressing chart that I've included in the materials, and it's at pages 88 and 89. And this is a document from the US Department of State, and it helps to show who are the people who can immigrate through family members and when. So what you'll see at the top of the page is that there's a category, it's called a family-sponsored category number 4. These are brothers and sisters of adult citizens. So say today is the day the child, US citizen child, turns 21. They say, okay, brother and sister, I'm gonna help you. I filed for it, I got a visa petition approved for you. What can you do with it? Now, unfortunately, if you presume the family's from Mexico and you turn to you look at the bottom of page 89, top of page 90, what you see is that right now, for the brothers and sisters of US citizens from Mexico, the people who got their visa applications approved in 1996 are now eligible to become residents. So basically what they have is a 15-year waiting period from when they get a visa approved on a family petition to when they're actually eligible to adjust their status. And they have no ability to get a work permit or be here legally, technically, until 15 years from now. So for those, that 4-year-old has to turn 21, has to file a visa petition, has to wait 15 years to try to immigrate the siblings. And then the additional problem is that if the siblings enter the country without permission, or other family members did, whoever they're immigrating, because the person entered the country without permission, in all likelihood that person can't get their green card in the United States. They have to go back to Mexico, ask to be able to come back into the United States. But if they've been in the United States past their 18th birthday for a certain amount of time, when they go back to Mexico, they're barred for 3 or 10 years from ever trying to return to the US. So that's the unfortunate reality of family-based immigration, is that there are certainly cases, and I think the majority of people who immigrate do immigrate between employment and family-based immigration, but it's not an option for a lot of people, or it's not practically an option anytime soon, because the way that the immigration laws are structured and interplay means that although we value family relationships in immigration, we don't value them so much that everyone can do it very easily. So there are a lot of hurdles that come up for people who are going to be trying to immigrate through family-based immigration. So if the child you're working with has a parent who is a lawful permanent resident or has a sibling who's a citizen, it's always worth having the family-based immigration options analyzed. But it's not always going to be the case that you're going to come up with an answer that's going to help anyone in the immediate time. And so this is just, here I just put a couple of slides, some information about adoptions of foreign-born children, some additional requirements under Nebraska law for how adoptions can be handled for foreign-born children. But then also just a note, I don't know if has anyone here had training on the Hague Convention, International Adoption Convention? It's not an area of my expertise, and it's an area that I think is incredibly complex, but the Hague Convention went into effect in early 2008 and has created a lot of complex procedures that need to be followed to finalize adoptions for foreign-born children in the United States. And the reason it's incredibly important, I think, is because the US government will not recognize a non-Hague compliant adoption for purposes of immigration. So it's just one more reason to try to resolve children's immigration situation before any adoption is finalized, because you may or may not be completing a Hague compliant adoption, and if you're not, then even if the adoption is done, the adoption may not help the child to fix their own immigration situation. And again, this is really outside of my area of expertise, but what I will say is that there's a very long list of Hague signatories, and so many of the countries that you may be dealing with are Hague signatories, and so the Hague Convention will apply. If the country you're dealing with is not a Hague signatory, then you don't have to worry about this additional level of analysis. But it's something that for people who handle adoptions, I would say probably is would be worth having a morning MCLE on it and have someone come in who has a lot of background on it, because it is something that can be incredibly complex and new. I just have some information here about how people would actually physically go through the petitioning for family members. And we talked a bit about the preference categories. This is the way that the immigration law breaks down who gets to immigrate and when. And what you'll see is that US citizens generally are more easily able to immigrate family members, and immediate family members of US citizens at least don't have to wait in these long lines of preference categories if they're categorized as immediate relatives. But if they're relatives of lawful permanent residents, or they're not immediate relatives of US citizens, then they have to get in line behind all of these other people in the massive line that exists to be able to take advantage of the immigrant visa. And then it was something we already addressed, which is when can you apply for your green card if you have a family-based visa, and that's what the visa bulletin shows you. And so it shows you that in some cases the person may wait a couple years, but in some cases the person may be waiting for 15 years or more before they're eligible to take advantage of a visa. This is just another way that family-based immigration is a little different, and why SIJS is a great option for some kids, because like we talked about with family-based immigration, generally speaking, if someone came into the country without permission, the law has said we are going to penalize you for doing that. And so we're not going to allow you to get your residency here. You have to leave and come back. That is not the requirement for SIJS, and that's why the process can take place here and really quickly, because it's happening outside the family-based context. Now, there's something also called Relief Under the Violence Against Women Act. The basic thing for you to know about this is that well, the first thing to know is that it's not only for women, it's for men and women and adults and children. It's basically a way for a person who has been abused by a permanent resident or US citizen to take that abusive person out of the immigration process. So it's like a parallel to the family-based immigration, but it doesn't require the participation of the abusive person who may be holding the immigration status of the undocumented person as part of their abusive ploys. So what has happened with this relief is basically you would need someone, say it's a child, would need to have a US citizen or lawful permanent resident parent who has abused the child, and that the child meets some other requirements. And they're just listed on here. Living with the abusive parent at some point, child is unmarried and under 21, has good moral character. You need to show that the child has suffered abuse that amounts to battery or extreme cruelty. If the child can meet these requirements, and again, this is not just for children, so you might have a case where you have a US citizen child and the parent, the mother, is undocumented. If her abusive spouse is a US citizen or a resident, it's possible she may qualify for VAWA relief, and the child may not need the help if they're a citizen. But it's a really good form of relief to know about, but again, it really is dependent on the immigration status of the abuser. So if the person has an abusive spouse who's also undocumented, VAWA is not going to be an option for them. If they're not technically married to the abusive person, VAWA is also not going to be an option, because VAWA really is proceeding like a family-based case. So it needs to be a relationship, a legal relationship that is recognized by the Immigration Service as a spousal relationship. I think that there's an exception for a bigamist relationship where you think you're married to the person, but you're not really because they were married to someone else. But generally speaking, you need the parent-child relationship. It could be an adoptive child, adoptive parent, step-parent, or biological parent. And so there are these basic requirements. This is just a process for it. This kind of immigration application is processed by the CIS office in Vermont, and it's all done on paperwork, generally by a unit of people who are trained in the dynamics of domestic violence and generally have a pretty decent understanding of how domestic violence cases work. The one thing that's important to know is that the standard for the approval of these cases and the evidentiary showing you need to make is that the Immigration Service, you have to show by a preponderance of the evidence you're eligible, but the Immigration Service will accept any credible evidence on these cases. So it's not required that there be a restraining order. It's not required that there be a police report. You could have declarations by people, including the applicant. You may have or could have declarations by people who work for the Child Welfare Agency who have knowledge of the abuse. And so there are ways in which juvenile court documents or the work that you do may be relevant to these claims, but again, there are not clear requirements that there needs to be law enforcement involvement. And again, this is for adults, but it's also for children. The thing to keep in mind also is that there is the requirement that the child or the parent have suffered abuse that amounts to battery or extreme cruelty. So these are not cases where an abandonment theory like SIJS would work. You actually need battery or extreme cruelty, although what the parameters of those two things are is not clearly defined, but just for you to be aware, there is that requirement. Again, this is the process. If the applicant gets an I-360 approved, They may still have to wait a long time to get their green card, but at least they can have a work permit while they wait. And they also may be eligible for increased government benefits. And I think the rationale there is that some of this is designed to help people leave abusive relationships, and so to the extent that they can work and get benefits, that may help with the process. The U visa is, I think, aside from SIJS, the thing that is like I want you to take away most from today. Have you ever handled a U visa case? Or it's
I have some of my clients, because I do pro bono for women that have been abused, that are undocumented. Use Max out of Lincoln, Graves, it's a Lutheran.
right. So in your resources at the end, you're going to see lists of people who handle different cases, and I've tried everywhere I could to tell you the people who handle U visas. And the reason they're going to be incredibly helpful, I think, or could be to you, is that the U visa is this very generous form of immigration relief that can cover a lot of situations that may be excluded by family-based or VAWA relief. It's basically a visa that creates a path to lawful permanent residency, and it's for people who've been the victims of crimes who've cooperated with law enforcement. And the thing to know about it is that the crime could be a domestic violence crime, it could be child abuse. So you may have children on your caseload who have been the subject of this kind of abuse, who cooperated with you in the investigation of the crime. The other thing that's important to know is that the investigation need not result in a conviction of the perpetrator. It doesn't actually have to result in the opening of any formal criminal case. It's enough that there would be investigation even by Child Protective Services alone. And so I'll just go over what the requirements are, because this is actually a place where HHS, if it chose, could have a very significant role in these cases. Go ahead.
So cooperating with law enforcement, if the child is abused and cooperates with Child Protective Services, you're saying that falls under
Yes, that falls under there. And the thing that's really, I think, important, and reason why I think it's really important to know about, is that this is a form of relief where you can actually address the immigration situations of a whole family. Say you have a child who's abused and comes into your care, into the care of the state. Maybe they were the only victim of abuse, but they have an undocumented mother and undocumented siblings. If the child qualifies for a U visa, they can actually include the parent and all the siblings who are under 18 and legalize everyone together. And so this is actually, I think, a really good alternative to SIJS for some families where you are going to be reunifying the child with one parent. Because if that parent is undocumented, or the child has undocumented siblings perhaps, there may be situations where you fix the child's immigration case, but you have not necessarily addressed some of the underlying issues that maybe were the cause of the child coming into the system to begin with, or you may have a child who wants to immigrate their parent. And so the U visa could actually incorporate or cover a much wider number of people in any given case. And again, this could all be done or certified by HHS.
This visa was used in a pretty infamous case that came out of Lexington, where the school teacher was sexually abusing the young Mexican man or boy and took him back to Mexico. And through the U visa, he was able to address both.
And so the comment was about a child who was abused by a school teacher in Lexington and actually was taken back to Mexico, but through a U visa was able to adjust his whole family. The other thing about the U visa that's important to know is that it is actually applicable. The crime needs to have happened here, but the person could actually be outside the United States. So in a case where, say you have a child, victim of child abuse, U visa eligible, mother gets deported, she was not the abuser. You get a U visa for the child can actually bring the mother back legally to the United States through the U visa. And so there could be a way of family reunification that actually reunifies the family here, and this is even if the parent has been deported. And it also applies to crimes that could have happened 10 years ago. There's no time limitation on the U visa. What you need, I'll show you, these are the requirements. Suffered the harm, has information, provides or is helpful, criminal activity in the US. If you have a very young child, just important to know, an adult can step in and be helpful for the child. Maybe you have a 4-year-old child who can't, or you don't want them to have to go through some long cooperative acts. So you can have an adult who provides or is helpful with the information on behalf of the child. These are the kind of crimes that are covered, sort of the parade of horribles, but these are the kind of crimes that are covered by the U visa. So it's just important for you to know, someone getting their purse stolen, someone having their car robbed, this is not going to get them a U visa. They're pretty serious crimes, but honestly, I think they're unfortunately ones that you may see from time to time. One thing that's useful to know, I'll talk to you, these are the list of crimes. What's important to know about the U visa is, just like in SIJS, you need the SIJS order to apply. In the U visa, you need a U visa certification to apply. And if you don't have the certification, you can't apply. This is where a criminal court judge, a DA, an HHS official could be the certifier on the U visa. And basically, they're certifying that the person was a victim of the crime, and they're certifying that they were helpful to law enforcement. They don't have to certify the harm. They're not required to talk about whether it was harmful or not, but they need to verify that the person was cooperative with the law enforcement investigation. And so again, there is a listing of who could possibly be a U visa certifier, but it also includes, in the regulations, includes Child Protective Services. And so around the country, in LA, Riverside County, a couple other places, there is a designated person within the Child Welfare Agency who is the U visa certifier. And again, you can remember, this is, if the child is a victim, they can get a U visa, include the family members, although not the abusive person. But also to remember, if the adult is the victim of the crime, that adult can include her children on the application, children under the age of 21. So it's something that it moves in all directions, which is incredibly helpful. It does not skip generations, but it does move in all directions.
Does that include family members that are outside of the U.S. and have never even been in the
It includes family members who are outside the U.S. who have never been here. So say you have a woman who has 2 children in Guatemala, comes to the U.S., victim of a crime, gets a U visa. She can immigrate her children, bring them over as derivatives on the U visa. So they don't need to have been here before. Most of the times they are, but there are family members who may be abroad, either used to be here, left, or never were here. They can be included on the U visa as well. And again, it can move both directions. It could be the child here bringing parents, it could be a parent bringing a child. Spouses. I'm not spouses, siblings and spouses.
some cutoff as far as familial relationship?
There are some cutoffs. Yeah, no, not second cousins, but you can do spouses, and there's some age limitations, but siblings, parents, children, spouses, it doesn't extend beyond that. It can be adoptive people, but I think it doesn't extend to grandparents. It's not aunt and uncles, it's not cousins. And again, like I mentioned before, the crime is something it conceivably could have happened long in the past. The requirement you need the certification means that the older the crime is, perhaps more challenging it will be to get the certification signed. But if you get a certification signed for a child, say the crime happened, I don't know, years ago, as long as you can get the certification signed and you meet the other requirements, the Immigration Service will adjudicate and approve those applications. So it's, the sooner it is after the crime, the better, but you don't have to, you could have been cooperative 5 or 10 years ago. And if you can get someone to certify, then that may be an option. It's actually a good option if you have a child you're thinking of, like, oh, they should have gotten SIJS and they didn't because we didn't know, but they were the victim of a crime, and you have documented that, and either the police or HHS would sign a cert. Even if they come into you and they're 23, their juvenile case is closed, they actually may still have an immigration option and potentially, may be able to benefit siblings or a spouse if they're married now. Did someone else have a question? Go ahead.
For a victim of a crime, like if they're applying for a U visa, say they're 22, would they be able to legalize their 40-some-year-old mother, even though, what are the age limitations?
I think that my understanding, and I can double check this, is that you have to be under 21 to immigrate a parent, and if you want to immigrate a sibling, that sibling has to be under 18. So there are some cutoffs. But the parent, I think, if you're 22, if the victim of the crime is the parent, I believe if you're 22, you're going to be out of luck, but if you're under 21, you could be immigrated by the parent. So there are some parameters in terms of age, but they're honestly somewhat generous. And again, there is no time limitation on the U visas. So I included in the materials, just so that you have it, pages 92 to 94, I wrote up it's based on a real case, but I rewrote it, a sample U visa certification. And it's a sample that was signed by a child welfare agency. And so you'll see, I think in that case, I don't know how old I made it, but the crime in that particular case was back in like 1995, and the U visa was granted last year. So it was a very old case, but it was a clearly documented case with the juvenile court. So it's really, it's a great form of relief, and I think it is a good form of relief for keeping families together and addressing a broader range of immigration issues for families. The thing that's also nice about it is that, I'll get more info on the certifying agency, but the thing that's nice about it is that the U visa, if it's granted, is good for 4 years. You get a work permit, and after 3 years, you can apply to become a permanent resident. And the grounds of inadmissibility are even more generously waived for U visa applicants. So if you have the drug trafficking child who can't get SIJS, if they qualify for a U visa and you've got a lot of good equities, they can qualify for adjustment as a U visa holder. The drug trafficking ground of inadmissibility will not apply to them. So it is a good option to look at. And I think it's actually a good option when you're looking at SIJS to always be thinking about a U visa as well. And particularly if you're a parent's attorney, I think thinking about the U visa, whether or not the child gets SIJS, if the adult in the case is eligible, it could be incredibly helpful. And these are just some options about how you might try to get a certification through a juvenile court case or through a motion to the court or in an adult criminal case or through HHS. And this is just the process again. The U visas are adjudicated in Vermont. I don't know how you feel about the Vermont Service Center, but we love the Vermont Service Center. And so these are all adjudicated on paper, even the adjustments. And so what that means is that this whole process can be completed for someone without that person ever having to see the face of an immigration officer in an interview, which for some people can be an incredibly helpful thing that you don't have that interpersonal contact. Biometrics are done again. The person could get a work permit, become a resident. The one thing that's generally, I would say, good about the VAWA and U visa is, unlike the SIJS, if the case is not approved, generally speaking, the Vermont Service Center will close its beautiful green file and leave it, and the person will not be placed into removal. It would be an extreme case with probably, I would imagine, some very violent crimes or repeated immigration violations that would wind this person up in removal. So if you have a case where you feel like it's really borderline SIJS, you're really worried about the prospect of them going into removal, one thing we do think about is, could we do a U visa? Because even if it gets denied, there probably is not going to be anything after the U visa that would be harmful to the person. Again, that wouldn't be a guarantee, but it's at least in our experience something that's a little more likely.
I found that, like in Lancaster County, the chief of police does a certification on UVs. However, in different areas of the county, here in Nebraska, it's different individuals. And so, depending on what county you're in or what county you're dealing with, it's, you know, if you're going to do a UVs, you need to find out who that person is
Right.
that certifies
Mm-hmm.
and what they like and what they don't like.
Exactly. And so this is, the comment was on, you need the certification signed. It needs to be signed by the head of the certifying agency or someone designated by the head or a judge. So even if you're in a county where no one else wants to sign a U visa certification, if you get a criminal court judge to sign, they don't have to get approval from anybody. That's within their power to do. But if you're in a place where you want certification from the police, then it is true, you will go to the head of the police department or whoever is designated. But my advice is always talk to all the people who do U visas and figure out what they know about that area already. Figure out whether they're friendly to the U visa certifications or not, and what kind of proof do they want to see in a request. The good thing about HHS, were HHS to certify, is that the certifier would either be the head of your whole agency or one person who's designated by the head. And so if that is a statewide, applicability across the state, then you will have one person who would be doing the certifications no matter where the child or even the parent may be. And so that's, one thing to keep in mind. But again, because of the way that your system may be broken down, something that I might get a certification on in Lincoln, you may be able to do it in Lexington. And that's just the way it is, unfortunately, but that's, I guess, something we all have to deal with. Okay, there were some changes to the U visa recently in the Trafficking Victims Protection and Reauthorization Act. I'm not gonna, I have them here for you if you need them, but these are new changes. Again, the fees are waivable, and so this is also another kind of relief where the application fees should not be a burden. There's another kind of immigrant visa, I'm just going to spend a minute talking about it. It's called a T visa. It's for victims of trafficking. I think it's even less likely you're going to see this on your caseload, and I think that's sort of by virtue of the fact that trafficking victims are often incredibly well hid from anyone in any state court system. But this is a kind of immigration relief that's for people who have been the victims of severe forms of trafficking in persons. Usually these are going to be cases where people, for children particularly, sex trafficking or labor trafficking. And it's similar to the U visa in that it creates a temporary protection for them, a work permit, but also creates a route to get lawful permanent residency. It's adjudicated by the Vermont Service Center. The fees are waivable. The one thing that's incredibly helpful on the T visa to know is that Congress has decided that this group of people is particularly vulnerable and worthy of federal benefits. So if you have a person who is a trafficking victim and approved with a T, they're going to be eligible for a wider range of public benefits. And I've actually reproduced in the materials on pages 95 to 98 a chart that goes over federal eligibility for immigration, federal eligibility for immigrants for benefits. And so you'll sort of see a breakdown, who qualifies for what, and what you'll see often is that some of the only exceptions are trafficking victims, that people who have been trafficked may be eligible for certain benefits that others are not. So it's just a thing to keep in mind. One thing I will say is if in the unlikely event you do run into a child or adult trafficking victim, and I think that the requirement is for children, but the federal government requires that any agency that discovers a child who may be a trafficking victim must report this to the U.S. Department of Health and Human Services within 24 hours of their detection. So the federal government is very concerned about being aware of trafficking situations, actually, I think, put a lot of money into trying to find trafficking victims, and it has had limited success in doing that. So the T visa is one way to that they've addressed trafficking situations, and so I've just gone over the benefits. It's very similar to the U visa in a certain way, and potentially leads to permanent residency. They can do derivative status, parents and children, some even more beneficial changes for the T. And then the final thing we have is asylum, and we have 1 minute till lunch. And we basically covered asylum earlier when we were talking about different kinds of immigration status. But basically the asylum, again, is for people who, and I have children here, but it's children and adults who fear persecution in their home country due to race, religion, nationality, political opinion, or membership in a particular social group. Again, I think you're probably more likely to see people who already are refugees or asylees than you are to work with someone who's actively pursuing this kind of immigration relief. But it is important to note, if you have a parent who's in an immigration court already, they may be pursuing an asylum claim and might be including their child on it because it may be the only thing that they qualify for. But these are just the basic requirements. Let me get some water. And again, like I mentioned earlier, the general sense is, from my perspective, this is an incredibly difficult kind of immigration relief to obtain for someone. And so it would be a rare case, I would say, that I would be referring someone or suggesting that they affirmatively apply for asylum. But certainly, there are incredibly strong and bona fide asylum claims out there for children and adults. If you think at all a child might be eligible for asylum, having an attorney who has experience in asylum cases would be essential, I would say, to before anyone moved forward on any kind of immigration application for that child. And it's available for children who are in immigration court proceedings, and also available for people who want to file affirmatively. But like I mentioned before, the very low approval rates for asylum in immigration courts nationally and in Omaha suggest that it's not U visa. It's not an SIJS. It's something that's very sparingly granted. There have been some changes to asylum for children that are useful to know about, and they are giving the asylum office, even for kids in removal proceedings, the ability to adjudicate those cases. And significantly, I think for those of us who do immigration work, there is a 1-year deadline for people to file for asylum in the US. And so children, unaccompanied children, are no longer barred by that deadline. But adults and children who are not deemed unaccompanied are required to file for asylum within a year of entry. And so many people, even adults that you may see on your caseload, who have some very viable or very legitimate fear of return to their home country, may ultimately not be advised to file for asylum, not because of the bona fides of their case, but because they came to the US 4 years ago and they didn't apply within a year. And so the 1-year deadline, with some exceptions, is something that has made this kind of relief even more difficult for people to obtain. So something to be aware of. And so we're going to take lunch now. And the question I have for you guys, we're scheduled to break at 4:30. Do you want to take lunch for 45 minutes and we'll finish 15 minutes earlier, or do you want to have an hour-long lunch? Does anyone care? I see some nods for the earlier. So it is 12:30. Why don't we aim to start up again at 1:15, and then we'll move everything back 15 minutes, and then you'll be done by 4:15, okay? And I think the lunch is back there. If anyone has questions about specific cases or anything during lunch, I'll be here, and then we'll just get going again at 1:15. And